So the second or third day of the protest, and your mind goes straight to the Emergencies Act in the first text we get produced in these proceedings. Can you explain why that came so quickly to your mind?
I was being prudent. I was being prudent.
As early as the first Sunday of anti-COVID vaccine mandate protests in Ottawa, Canada's Attorney General was asking staff to look at the Emergencies Act. But David Lametti says that's because they had already looked at the Act during the COVID-19 pandemic and knew they needed to start laying the groundwork before it was even clear if the Act would be needed.
So it's something that I prudently raised. There's a question mark there, as you see. Something I'm prudently raising with my chief of staff to begin thinking about, to get the department to begin thinking about, in case we need it.
The substance of Lametti's testimony covered how a security threat is defined. The Emergencies Act refers to Section 2 of the CityNews Act to define what constitutes a threat to the security of Canada, something required to declare a public order emergency. The director of CityNews, Canada's spy agency, previously testified that vaccine mandate protests didn't meet their threshold, but he advised Justin Trudeau to invoke the act anyway. The federal government has argued CityNews' definition is too narrow and the Emergencies Act must take a broader outlook. But attorneys were unable to get answers on what legal basis is being used for that argument.
Was there any such document that you reviewed in preparing for your testimony here today that existed prior to the invocation of the Emergencies Act, that it was discussed, that isn't subject to solicitor-client privilege, that it was discussed that there was a broader scope of Section 2 as it applied in the Evidence Act?
Once again, that's a question that's asking me to effectively divulge legal arguments.
The inquiry was in a difficult spot. The Attorney General has not waived solicitor-client privilege and can't disclose what legal advice he gave the PM and Cabinet. Judged a quasi-constitutional right by the Supreme Court, it can be waived, but Lametti recalls it's only ever been waived by the federal government once in history.
Who is the person that we need to approach to waive this privilege so that Canadians can understand how the government arrived at this different interpretation of threats to the security of Canada? Who is this client?
Well, the client is the government of Canada. I don't think I'm telling tales out of school when I say that in closing argument, I believe these kinds of questions will be addressed by counsel.
In Ottawa, Xiaoli Li, City News.